Hey, you're about to see a clip from about a 2-hour discussion that Andrew Cake, Emily Albrecht, and I had about the Dobbs oral arguments that we recently heard at the Supreme Court. So this is a clip from that, but if you want to watch the entire discussion and Q&A, that link will be in the description. Thanks so much. Go to the next thing and kind of explain this idea about precedent.
Okay, so one of the big points of conflict is what it takes to overturn a precedent. And this is partially problematic because Casey says, well, you need these 4 things and then maybe extra sauce to overturn an important precedent. But a lot of the justices, and especially Alito in particular, were kind of pushing back on this. They were trying to push the counsel for Jackson and the counsel for the U.S. and see, well, do you really need these 4 factors? Do you really need changed facts of the case or something like that? Or can you overrule a case because it's clearly wrong? Egregiously wrong was the phrase that was being used by the counsel for the state of Mississippi. And so Kavanaugh kind of outlines some of it.
Yeah,
Josh,
there was
do
a
you want to
really
talk a little
interesting
about that?
exchange. Yeah, I thought this was a super interesting exchange. So Kavanaugh functionally says, the court has been forced to pick sides on the most contentious issues of debate. Some argue that since the Constitution doesn't mention abortion, that the Supreme Court should be neutral on it too. Wouldn't overruling Roe and Casey return us to a neutral position? And then Rickleman, the lawyer for the Center for what is it, Reproductive Choice? Am I getting their name right?
Jackson Women's Health Organization.
Okay.
I think. No. Yeah, she's with the Center for Reproductive Choice, but she's representing Jackson Women's Health Organization. Yes,
okay.
You're correct.
Yeah, that's right. So C basically says, well, the court rejected that argument in Casey, and it wouldn't be neutral since abortion rights is based on liberty, which is in the Constitution. States shouldn't take control of women's bodies, or else women will never have equal status. But then Kavanaugh pushes back and says some of the most controversial cases in this court's history happened when we overturned previous cases. So if we think that the prior precedents are seriously wrong, why should we not return to a position of neutrality? And I didn't think Rickleman's response was that good. He said the view that a previous decision is wrong is not enough to overturn. The state hasn't made new arguments here, so we shouldn't overturn 50 years of precedents. I thought that was a terrible response to Kavanaugh's question.
Yeah, I mean, she's relying on the Casey test here. She's saying, well, there are no new facts of the case. The reliance interest is still there, and therefore it's not the court's business to consider whether to overturn Roe and Casey. And she's trying to argue, and the counsel for the U.S. tried to argue against Alito later, unsuccessfully, which I'm so excited to talk about.
Yeah, let's talk about that. That was amazing.
That the cases where the court overturned other major precedents were actually cases that were perfectly in line with the test in Casey. And then Alito kind of lays down the hammer. And so Alito has this exchange with the counsel for the U.S. in which he presses her on Plessy v. Ferguson as one example. For those who don't know, Plessy v. Ferguson was the separate but equal case. It was the Supreme Court declared that it was an acceptable thing under the Constitution, even with the Civil War amendments, for the South to segregate facilities based on race, as long as those separate facilities were equal in some sense that I'm sure was circumvented frequently. And so that was finally overturned in the Brown v. Board of Education case, in which segregated schooling was found unconstitutional. And so Justice Alito asked the counsel, what if the year after Plessy was decided, we had another case come to the Supreme Court in which we had the opportunity to overturn Plessy? Should we do that? And what he's doing, and he's stipulated, same facts. The information is the same as at the time Plessy was decided. And he's presenting the counsel with a dilemma. Either she has to affirm that you need new facts or some new data. So Justice Breyer kind of tried to hand out the line that, well, we had all these new facts because we discovered that there were psychological harm to people, and so we didn't know that at the time of Plessy, which is a terrible argument. It's a terrible argument for why to keep segregation legal. And Alito basically says, did we need that data, or should we have overturned segregation at the time? Like, did we need 58 years of data on segregation? And she doesn't want to have to say, yes, we did, because she doesn't want to stand for 58 years of segregation under Plessy, but she also doesn't want to say, no, we should have overturned the egregiously wrong precedent at the earliest opportunity, because then it undercuts the stare decisis argument against or in favor of maintaining Roe or upholding Roe and Casey. And what she did was she said, well, yes, we should have overturned Plessy because the facts of the case were wrong at the time, but we've never in our history overturned a case in which there weren't facts changed, which is to say it's a non-answer. And yeah, she just...
that was one of the better moments.
It was really clear, because I think most people would agree, even lawyers before the Supreme Court would agree, that we should have overturned Plessy at the earliest possible opportunity. And there were powerful dissents. Justice Harlan, for example, wrote a powerful, if slightly conflicted dissent, in which he argued that the black-white segregation under Plessy was wrong at the time it was decided.
Once again, that was a clip from about a 2-hour discussion that we had live about the Supreme Court oral arguments in the Dobbs case. If you want to watch the entire discussion, that link is in the description. And subscribe to this channel if you want more pro-life training material like this.